just in my opinion, mostly bad. I'm going to then talk about strategies for protecting the cost basis of your home. And then we'll talk about how to potentially protect rental and commercial property from reassessment under Prop 19. And then we're going to have our questions and answers through the Zoom chat. And what I'll do is I'll go through all the questions so you can write them out whenever you want. And then at the end, I'm going to go through those. I'll also try to throw in a couple of amusing cartoons to keep you all awake and reward those people who aren't showing up on their phone. So first, the required legal disclaimer. This is a general information seminar, so don't try this at home unless we do an individual consultation to make sure that everything you're doing is appropriate for you. A lot of what I'm going to talk about won't affect everybody. The other thing is every county has their own assessor's office and they do their own thing. So the results in San Mateo and Contra Costa may be different. One county will be easier to work with than the other. Unfortunately, all of the counties seem to be closed right now, and none of them are responding to my phone calls and emails to get a little information for everybody and answer some specific questions I've been given. So talk about a perfect storm. We have this huge tax bill going into effect in February, and no one at the counties are available to help us. So I am not giving, again, specific legal advice, so be careful before you act. However, there is a hard deadline of February 15th for some of the opportunities you're going to be given today. I will be posting this presentation and recording it. I will use whichever one comes where I look better this week or last week. And then I'll get those up in the next day or two on my website. And again, please don't try this at home. I had somebody email me this morning from last week saying he knows exactly what to do and he's going to go online and try it himself. And that is a terrifying thought and will make a lot more work for me. So for those of you who don't know me, I'm a state bar certified specialist in estate planning, trust, and probate law. I specialize in writing and repairing estate plans, probate and trust administration. That's pretty much all I do. My favorite cartoon's the one on the bottom right. Dad at the kitchen table with his daughter saying, "Daddy doesn't know why birds migrate. Ask me about ways to avoid probate." Okay, we have an emergency system going off somewhere. And that messed up my moving my screen. My co-presenter is Michael Schachter. He is a business law attorney and handles business and real estate in Walnut Creek and specializes in business formations because that's going to be one of the recommendations or options that you're going to have to protect your businesses. So Michael will be available to answer questions about corporations, LLCs, and other fun things later in the program. So first of all, a little background, Prop 13 101, most of you hopefully know this. Your current property tax is about 1.25% of the assessed value of your property. The assessed value varies around the state, and the assessed value is an extremely important concept for our discussion today, because when we talk about reassessment and other issues and how much you can pass, it's not based on fair market value. It's based on the assessed value. The assessed value of your property is what you paid for it, plus any construction additions, plus usually 2% a year for inflation. And that's the most the county can assess you for. So this assessed value can be found on your property tax bill. I had a client check last week and his assessed value was less than 10% of fair market value. Assessed value changes when the property changes ownership, except when it's a parent to child transfer or a parent to grandchild of a dead child transfer. So that's very important. Those are the two exclusions we currently have, the parent-child and parent-grandchild exclusion. The assessed property value, again, you can find on your property tax bill. So what does Prop 13 get for your heirs? Your principal residence can currently be transferred to your heirs, no matter how much it's worth and no matter what they do with it. Plus, $1 million of other property at the assessed value. So that means it could be worth a whole lot more than $1 million. Plus, this is important. Hello, Bill. Welcome back.
Thank you.
I'm going to mute you. The $1 million, in my experience, when I have folks pass away, we just ask for a reassessment exclusion on everything. And the reason is that one county doesn't necessarily know what you're excluding in another county. So I've saved people reassessment on millions of dollars worth of property. That's where we are today. Sandeepa, we've got some waiting room folks. Please let them in. So again, we're going to focus on right now, you can pass principal residence and $1 million of other property at assessed value without any reassessment. So now let's talk about Prop 19. Here's the good part. For people who are 55 or older, disabled, or disaster victims, you can now move statewide 3 times and keep your Prop 13. So you get a low property tax basis and you can move anywhere you want. You used to be limited to just 11 counties who would let you do it. I suggest avoiding the purple counties right now. The move has to be within 2 years of selling your old property, and you can't give it away. You have to sell it. It actually has to be reassessed. If the new property costs more than the old property, then you'll be reassessed for the difference. So this is not only a benefit for these folks, but also it's kind of an idea of how to get people to buy and sell more property in California. So that's the good news. You can move more. The bad news is that basically your heirs lose the Prop 13 basis. There's one little exception, and that's it, folks. So the exception is that your principal residence will be exempt if it's worth less than $1 million plus the assessed value, and the kid moves in and lives there. And then there's paperwork that has to be filed within 1 year to preserve the Prop 13. It's currently 3 years. And you'd be amazed how many people blow that 3-year deadline. Because I get a lot of folks, they inherit property and they just leave it in the estate. So they'll leave it in the living trust, live in there, and then they won't do anything until something comes up, and then it's too late. So that's a very important deadline. Again, if the property is worth more than that $1 million, then you'll be reassessed at everything over $1 million at fair market value. So that's the only exception that Prop 19 allows to Prop 13. So that's something we have to look at carefully if you have a property that's worth over that $1 million. I'm just admitting some more people here. We're going to hit that 100 mark any second. Good thing I got dressed up today. So the bad part is that your rental properties, your commercial property, all that, there's no exemption for that at all. So we have to do something. So next part, how do we protect the tax basis on your home under Prop 19? Easy, we give it away now, either outright to your kids or child, or in an irrevocable trust so your child can't do crazy things with it. If you want to do this part of the planning, you have to have it recorded by February 15th. I'm recommending February 1st because the county recorder's offices are all closed and things have to be mailed in. And I don't even know if people are working there right now. So it's going to be some chaos. So the pros and cons of just deeding your house to your kids. It's easy, it's cheap, it protects the Prop 13 for your children. Any gift like this will require you to have the property appraised and file a gift tax return. The purpose of the gift tax return is really to eliminate gift taxes. If you gift your property to your kids and you don't file a gift tax return or deal with the gift issues, then there's going to be gift taxes, interest, and penalties that are going to accumulate that'll be horrible. Oh, so most people are familiar with the gift tax rule, where it used to be called the $10,000 rule. It's now $15,000 you can give per person per year. But the important part to remember is you can use your lifetime gift and estate tax exemption anytime you want. That's $11,580,000 per person. This is a very good time to use it because the new administration wants to get rid of it. And the old administration's rules were temporary, and it's going to drop in half anyway, even if the new administration changes nothing. It expires in 2025 and will go down by half. So this is an opportunity to use this gift and estate tax exemption that's probably going away anyway. So there will not be any tax on the gift. But the problem with just deeding the house to your kids is now they're in charge of the property, and you're going to have to do something to make sure they can't evict you if they get mad at you. There's a 30-year rule, by the way, if you want to lease back the property. The property will also now be subject to, if your kid declares bankruptcy, gets divorced, becomes incapacitated, or dies, it becomes part of their bankruptcy or probate estate. And that does not sound like a very good idea to me. The other thing is if you have a mortgage on your property, this will not be allowed by the mortgage company without an assumption or refinance of the mortgage by your kids. If you have no mortgage, no problem. But don't wait until February 15th and find out that, that you can't do this with the mortgage company. One of the most important things to consider when making any gift is cost basis. So a lot of folks understand this, but I want to explain real carefully. If you own your home, your cost basis is basically what you paid for your home and improvements. It's the assessed value. It's not the current value. If you have a rental property, your cost basis is what you paid minus your depreciation. If you sell a property, your capital gains tax is the profit you make over the cost basis. The way this works in estates is if your heirs inherit your assets, stocks, bonds, mutual funds, real estate, they get a 100% step up in the cost basis and can sell your assets without any capital gains tax. If you make a gift, you're stuck with that cost basis. It moves along to your kids, and they have to, when they sell the property, they're going to potentially have a very large tax. So if you're going to transfer your home, do not do it if they're going to sell it. This is only if you know for sure that your kids are going to keep the home. The other thing you have to look at is how a gift of your home affects your estate plan. So if you give your valuable home to one of your children, how's that going to affect your other children in your estate plan? I'm already talking to folks about setting up their estate plan to literally say, I gave my house to child 1, so child 2 and child 3 get the value of the house off the top before everything is split up. So we need to make sure that the estate plan is up to date to consider this. So the bottom line is giving your house to your kids is best if the child is going to live in the house and never sell it. I'm not even sure the answer to this. What if you've got 3 or 4 kids? Do they all have to move in together? That might not work out too well either. So this would probably work best if you want one child to have and keep the house. Now, a better option than just giving them a deed to the house perhaps would be to put the house in an irrevocable trust so that they can't do anything stupid with the house, and the house will be protected from their debts, marriages, incapacity, and death if something happens to your kids. So this will still preserve the Prop 13. It will give you some control over the property now. And everything else is kind of the same. We still have the mortgage issue, and we still lose the step up in basis. So if you really want to gift the house to the kids, this might be the best way to do it. And again, if your house is not worth over $1 million beyond the assessed value, I wouldn't do it anyway because it's not worth all the downsides. But I know there are several folks from Hillsborough on here. This is for you. All right, number 2, how to protect the tax basis on your rental property under Prop 19. So if you have a house, a vacation house, even if you don't rent it, any other property other than the primary residence, there's no longer any exemption for it all if you die. So one option is we give it to the kids right now, whether either outright in an irrevocable trust, but it has all the same drawbacks. You lose the step up in basis over the property, and they would also lose the depreciation that that would give them. So think about this. You have a rental property, you've owned it a long time, you've depreciated it and as much as you can, so now your cost basis is actually zero. So if you gift it to your kids, they ever sell it, it's 100% taxable. If they inherit it and keep it, they can depreciate it based on the full fair market value, and that's worth more than preserving the Prop 13. Your other options, and the best option I think here, is to create an entity, a limited liability company, a corporation, a partnership, to hold that and own that property. And that will allow us not to transfer the deed when you die, we transfer the entity. And that may be the key to the planning here. So let's talk about business entities. My recommendation is the best option probably to protect your property from being reassessed is own it in a business entity. And a business entity like an LLC is usually recommended anyway for a rental property, because this protects your other assets from liability if there's any lawsuits involving that property. So it's easy and inexpensive to set these up, and it gives you a lot of protection. It also gives you the power down the road, once you set this up, to sell or give away shares to your heirs, family, friends, business partners. It's a lot easier to do that than messing with the deed to the property. It's very important right now that we don't mess with the deed to the property. So if the property is owned by a business entity, all we have to do is transfer shares or stock in the entity. You can control the entity. Even if you end up having kids or other people, you give them shares, you can still have total control over the entity and your assets. There are tax implications to the business entities. So I always recommend that folks talk to their CPA and figure out which entity will be best for them. There is obviously a cost to set it up and maintain a business entity. If you put an asset in a business entity, it will still get a step up in basis when you die. But if you give away shares to your kids, there's no step up on their interest. But it's often a very good idea to give shares to your kids, because if you own 100% of a property and you die, it's valued at 100%. If you give your kids 5 or 10% of the entity over the years and you die only owning part of the property, you may very well be entitled to a partial interest discount on your estate tax return for doing that. And that can be a very valuable way of doing estate tax planning. The other nice thing about business entities is there's no deadline. We don't have to do it in a rush by February 15th, because we're not transferring ownership to anyone else. You're transferring ownership to your own wholly owned business entity. So we have time on that and other advantages. Oh, we're here. We're pretty much at the last slide. So this is a very important piece of the code. I'm trying not to be boring and read codes to people, but California Revenue and Taxation Code says that for purposes of the parent-child exclusion and reassessment, this does not include interests in legal entities. So the purchase or transfer of ownership interests in a legal entity, such as corporate stock, partnership, or LLC interest, is not a transfer of real property for reassessment unless you transfer over 50% to your kids. There is also something called the mirror rule. If you own 100% of the property and you own % of the business entity to start with, it's a mirror, there's no reassessment. If you have business partners, as you can transfer the whole property into the business entity without a reassessment, so long as the ownership of the business entity stays the same. And then you can make changes after that. There are some statute of limitations I'm noting here. So if you give away too much and you don't tell the county, they can go back so many years and claim reassessment of your property. But the big loophole all along for Prop 13 is business entities. And that's what I thought at first that Prop 15 and Prop 19 would be getting at. Now, Prop 15 would make a big difference, but thank God that didn't pass, because all property would be reassessed, all business property over a certain value. But the loophole that people have been using for years, they sell a big, building in San Francisco. If you just sell it outright, then the buyer gets reassessed. If you incorporate that building and just transfer the corporate stock, the buyer doesn't get reassessed. So this has been the big Prop 13 loophole all along that Prop 15 was trying to get rid of, but Prop 15 did not pass. But we could take advantage of this loophole to help protect our families from huge reassessment. Now, again, this is all going to be posted online on joelharrislaw.com, so you can kind of look at the slides, and I'm happy to send you the slides if you want them too, because I went over it fairly quickly, so I didn't lose anyone's interest. So now it's called Q&A with Comic Relief. I've got some cartoons up on the screen, and I'm going to open up the chat room here if I can remember how to do it. And I'm going to start answering your questions, and Mr. Schachter will answer any questions you have about business entities, and we'll keep it going for half an hour or so if you want us.
So I have a question. Can you hear me?
Yes, I can hear you. I'm just trying to figure out, for some reason, Sandeepa, that my chat's not coming up right now. Maybe I'll stop
when you're ready.
Yeah, give me just a sec. It's a technical thing. All right, perfect. Let me get the chat here. I've got 74 people online. So if possible, everybody just type your questions into the chat. I can't have everyone talk at the same time. Oh, I've got 7 questions already. So I'm going to start with the questions on here. When the last parent dies and several properties in LLC are delivered to the children, at that point, can they divide them up as they wish with no tax implications? That's definitely an it depends question. But what will happen is when the last parent dies, we need to keep it within the LLC. So the kids are going to own the LLC, not the properties directly, and then they can decide what to do with the properties, sell them or continue to manage them, put them in their own LLCs. But whenever the deed itself changes, the county assessor is going to look at it with a microscope and try to reassess you. Next question, to preserve the Prop 13 property tax benefit, can I move some of my properties into an irrevocable trust and leave the others in my current revocable trust? The answer is yes, but that turns out to be a more important question than you know, because after last week's program, a lot of folks said, okay, I want to turn my living trust into an irrevocable trust, and I screamed and ran away. You never do that. These possible strategies, an irrevocable trust, a gift, an LLC, this is in addition to your revocable living trust estate plan, not a replacement for or instead of. So this is extra things you can do. So if you have a living trust, you might, and you have a rental property, or you might put that into an LLC or an irrevocable trust, but you're going to keep your living trust. The max lifetime gift is $11,580,000 per person. With a couple, that gives you over $23 million in gifting power. So, question, an irrevocable trust can't be changed without permission of the beneficiary. If there's an, hold on, bear with me, this is a long question. The question is, if you have an irrevocable trust with one child as beneficiary, does anyone else have any say in making changes to it? And the answer is no. My home is in a living trust. Do I need to change it to an irrevocable trust? You would only want to consider that if it's worth over $1 million beyond the assessed value, and you're going to leave it to a child who's going to live there forever. When more than 50% of an LLC changes ownership, the property gets reassessed for property tax purposes. Maybe. It does now if you gift it to your kids while you're alive. Yes, so we have to be careful, but the concern really is doing it now on the deed. How does anybody know if you gifted LLC shares? When I usually do it, we just change it in the back of the LLC on your schedule of ownership. So we don't record that anywhere. So the key is not to ever change the deed, just try to change the business entities as much as possible. Yes, Julie, farms have the same exemption as personal residences. I don't mention them because in 30 years of doing this, I have yet to encounter a farm in an estate that I've handled. Can you transfer to an underage grandchild without doing an irrevocable trust? Yes, but it's not a good idea because now that property is frozen until the grandchild turns 18. Literally, you can't rent it or borrow or sell or do anything without going to court and getting guardianship, and that would be messy. And the other thing is that you can't send, if the grandchild's parent is still alive, the one who's related to you, you'll be reassessed if you gift it to the grandchild. I never suggest giving anything to anybody under 25, 30, or in some cases 75 years old. It's usually best to use a trust and put proper restrictions on them. Don't have children, leaving house to sister, reassessed. The only exemption that even exists right now is parent to child or parent to child of dead child. Now, that means that if grandparent to grandchild is reassessed, unless you kill your child first, which I don't recommend, or you can leapfrog it, you can gift it to your child and your child can gift it to their child if we do it fast. But giving it to siblings doesn't work. And that's a big mistake a lot of people make when they're dealing with probates and trusts. So if you inherit property from a trust and you put it in the name of the kids and then they transfer it between each other, they're all reassessed. And I have that happen a lot. And then people come and see me to fix it. And it's usually too late. Can you put multiple rental properties in one LLC? Absolutely. Can rental properties be moved in an LLC? Yes. Doesn't have to be a new purchase. We can take your existing properties and put them into an LLC. The only thing is we have to use the mirror rule, whether it's an LLC, a partnership, or a corporation. You have to, when you put the property in initially, the ownership has to be identical. So if you own 100% of the property, you have to own 100% of the LLC or corporation when you put the property in. Then you can change ownership on part later on. Can you add your kids to title and not redo your loan? You have to ask your lender about that. When you die, you can. The law is when you die, if your kids inherit a loan, they assume the loan and the lender is stuck with them. But if you have a mortgage or a reverse mortgage, usually if you add a kid and you stay on, I've never seen a problem. If you give it to a kid and they find out, maybe a problem. If you put it into an irrevocable trust, definitely a problem. They're not going to like that. You have to get the permission of the mortgage company. Oh, you guys are doing a great job on the questions. There's loads of them. My parents move out of the house into assisted living. Are they now excluded from being able to pass on the basis when they die? Nope. We can still do that. But if they die after February 15th, then you're going to be reassessed on it if the value is over $1 million. Let's see. So protecting your heirs. All right, so the next question has nothing to do with what we're talking about, but it's kind of interesting, so I'm going to mention it. But it's not the CARES Act, it's called the Secure Act. So for planning purposes, we have this new act that went into effect last December called the Secure Act. And the Secure Act makes IRAs better for you and worse for your heirs. So you can now wait a little longer before you draw money out of your IRA, but there's no such thing as a beneficiary IRA over the lifetime of your heirs anymore. They only have 10 years to draw it out. So the question was, well, if I make a trust or an entity the beneficiary, does that help? And the answer is absolutely not. That is a horrible thing because trusts have to cash them in all at once. And an entity probably would too, because only a person can distribute it. You want to make sure, listen up, everybody, do not make your trust the beneficiary of an IRA or 401k, except maybe if your trust is a special needs trust for severely handicapped kids. But talk to me first. Do not try this at home. All right, but I've done whole seminars just on the Secure Act and IRA planning now. Next question, is there any change in property tax treatment of previously inherited homes if they are not occupied by the heir? There's no problem if you've already inherited, if you filed the forms with the county. It's called a claim for reassessment exclusion form. You have to have that on file, or when the law changes, the legal term is you're screwed. And I remember I told you, I get a lot of folks in inherit property, they just leave it in the trust and they never get around to it. I've got a nice house for sale in Walnut Creek that was sitting in a trust for 22 years because no one ever bothered to take it out. And we're going to have to pay quite a tax on that right now. You talk more about more than what happens to an LLC when over 50% transfers on death. I don't care about what happens on death on the LLC. It's what happens if you transfer over 50% when you're alive. Then it's not subject to the no reassessment rule when you put your property in, if you're giving over 50% interest to your kids. If you die, I'm not concerned about that. If I move into my rental that has a very low property tax base and start claiming that as your primary residence, can I then transfer the tax base to a new property up to 2 more times? Well, that's an interesting question. I don't see why not. The rule currently is if you live in a property for 2 out of 5 years and have considered it your primary residence, you can sell it with either a $250,000 capital gains exemption for a single person or $500,000 for a couple. So I don't see why, if it's a primary residence, you still couldn't make that change. Hey, Mike Stoiber, how you doing up there? All right, for some reason, John, you're stuck on my screen here the whole time. So if you can try to hold steady, I won't get too dizzy. And by the way, feel free to send some business entity questions to Michael Schachter. I'm doing all the heavy lifting here. We own a home and are with your child. Your child co-owns the home now. She lives in the home. Well, what will impact will the new law have? Well, when you die, your child's going to lose the Prop 13 on your half. So that might be a perfect situation to transfer the home if your child already co-owns the home and you know they're going to live there. So that's definitely worth talking about. Okay, my home is in a living trust. When I die, my adult children plan on keeping the house and sharing it. Is there a good option for this situation? Yeah, we're going to need to talk about that. So that might be, it all depends on the value of the home. Remember, if it's less than $1 million above the assessed value, there's no problem. You don't have to do anything. If your house is worth $3 million, then we need to talk. Which means if your house is in Walnut Creek, La Miranda, Danville, Alamo, San Ramon, and half of the peninsula, we still have to talk because property values are pretty crazy these days. Regarding farm parcels, what happens if there are multiple owners and multiple parcels and the exclusion is only for 1 million? Then it'll be partially reassessed. You want to have the whole thing reassessed, but I'm definitely not an expert on farmland. Hold on a sec, guys. The next question is really long. Here's Heather. All right, so here's a case where the parents own a significant amount of property. I think we should do some gifting or business entities, and I agree. That's definitely something that, Darren, that we should talk about. And you can gift again up to $23 million. But see, it has to be an individual analysis, folks, because I've got to see what the property tax benefit is versus the capital gains tax issue. And then I have to look at other heirs. I've had really bad luck with 4, 5, 6 different people suddenly inheriting a property together, and they don't necessarily get along. Just yesterday, I had a situation where 99% of the heirs and owners wanted to sell a valuable property, and someone owning 1% was holding up the whole deal and has been driving them nuts for about 10 years. So I like to be careful about setting up those situations. So very much a case-by-case basis. All right, I did all the questions. Ask me some more. And if you don't, I'm going to take you all off mute, and then you can just yell out questions. All right, you're all either off mute, or you can turn yourself off mute if you want to. And Mike Schachter's here too. And if you have any questions about LLCs or business entities, last week a lot of people asked me those questions offline, and I just forwarded them to Michael. Questions, comments?
Yeah, I have a question.
Yes, Julie.
Okay, in regards to an LLC, if one has multiple rental properties, you're stating that the LLC can hold up, is there a maximum amount of properties that can go into that?
Michael Schachter, that's for you.
Finally. Thanks, Joel, for letting me step in here. Julie, thanks for the question. That's a good question. There's no number of rental properties that could be included in an LLC. The issue is a business decision whether or not you wanted to put them all into one LLC or you wanted to make separate LLCs for each property. So, it's really a business call on your end.
Okay, could you explain what would be the benefit to have individual LLCs? To me, it seems very complicated, even prior to this initiative. The tax man and myself talked about it, but it seemed really problematic to put LLCs for each property. So if you could kind of touch on what would be the benefit.
Yeah, absolutely. So each LLC, some people, it depends on the property itself, if it's commercial or residential. I mean, if it's commercial, it might make sense to make each property separate for the liability purposes. The issue is liability and whether or not you want to protect that particular property and distinguish it from the other ones in case there's a loss. So, you're really separating the liability, right? So,
sure. Okay.
So it costs, so if you there's formation costs up front that you pay me to do, and then there's also annual fees as well that you need to pay the Secretary of State. For the LLCs, it's every other year, $25. You can do it online now. But there's also an $800 franchise tax board fee that's not prorated that would be applicable to each LLC. So really you need to ascertain each property and ascertain what the liability is for each one. If you feel pretty comfortable, in addition to the lease that you might have and insurance, separating them, then there might be one property in particular that might be more dangerous than the other ones. So you might want to separate them in that regard. So it's really a business.
Okay, so if you do put them all in one, that makes all of them exposed to liability. If you individually have an LLC, they're just limited to that one property, correct?
Exactly, yeah. And some people get pretty crazy with the LLCs, and then they make the manager or the member of the LLC another LLC, and sometimes you have 8, 10 layers, sometimes that gets expensive as well. But I mean, basically you have the corporate veil for each LLC, so you'd have to do something egregious to pierce the corporate veil itself. So, a lot of people make project LLCs for commercial real estate properties to separate them from the other ones. And you don't have to make different layers if you want. But if you feel more comfortable doing it, then you can.
Okay, thank you.
You're welcome.
All right, Michael, here's another LLC question. Some of these, by the way, if you folks aren't seeing all the questions, don't worry about it. Half of them are coming into me as private questions. So I just won't, I'll just change the names to protect the innocent. Al Capone wants to know, oh, here's a whole bunch of questions. Al Capone wants to know if they put their rental properties into the LLCs, and when they die and their kid gets the LLCs, will they get a stepped up basis? They also want to know the cost of setting up an LLC.
Oh, you can handle the stepped up basis question. I can talk about the cost.
Yeah, currently, yes, for stepped up basis. Michael?
Thanks, Joel. Excellent answer. A+. Cost of an LLC is the following. I usually charge a flat rate, generally speaking, if it's pretty straightforward, depending on how many members there are in the LLC, which is about $2,500, and that includes the filing fees. So you need a couple documents for the LLC. You need the Articles of Organization, which is the formal document that you file with the Secretary of State in California. We use a filing service here at our firm, so as soon as we received the signed Articles of Organization, we would file that. It's about $250 in filing fees. That includes the filing service. And then the rest of the amount would be applicable to our services to prepare and file the Articles of Organization, obtain your employee identification number, which is the Social Security number of your LLC. The main bulk of the fee is towards the operating agreement. You don't have to have a formal written operating agreement in California, but it's definitely recommended, and I always do it. So that would be an agreement between the members of the LLC. Those are the owners, and the manager of the LLC as well. That the manager is analogous to the board of directors for a corp. So in addition to that, there's a statement of information that needs to be filed within, I believe, 45 or 60 days of the filing of the LLC, and that's due every other year for the LLC. So generally speaking, it's about $2,500, and that includes filing fees. And then with the LLC, there's less formalities than a corporation, so you don't have to do annual minutes like you would, as long as it's in the operating agreement that reflects that. But you do need every other year to file a statement of information with the Secretary of State, which is you can do online now. Back when I first started practicing law many years ago, you used to have to send them in the mail. So now you can do it online. It's $25. We usually do that for you and set a reminder for you as well. So that's the cost. And there's $800 franchise tax board fee that's not prorated and non-negotiable that you need to file with your taxes.
So you're probably better off filing that in January than paying it right now, right?
Correct. Yeah, it's not prorated, so you would pay for the whole year 2020. There is, you can file 2021 LLCs, I believe the last 2 weeks of December. So if you wanted to get that ahead of time, I can prepare those documents for you, and they would record on January 1st. They would record now, but not be applicable to January 1st, 2021. So you could be exempt from the 2020 taxes fee of $800.
Any follow-up questions to that, folks?
And it usually takes about two to 3 weeks, generally speaking. The Secretary of State is about 7 to 10 business days, usually. But with the filing service that we use, the date that you submit it to be filed will be the filing date itself. So you might not get it back for about 2 weeks, but if you filed it today, for example, you might not get it back till about mid-December, but the filing date would be December 8th, 2020.
Just a quick follow-up on that. Did you say the California franchise fee, the $800, that's annually or one time?
That's annually.
Okay, all right. Thank you.
You're welcome.
So I've got lots more questions now in the chat room. And one question is, if your kids aren't going to keep your home, should you still do anything? And the answer is absolutely not. Don't do anything if they're going to sell the home. Who cares about the property tax basis if you're not keeping it? This is only for things that are going to be kept. If they're not going to live in your home, they're still going to get reassessed. The exemption is only if they move into the house. So again, if your kids aren't going to keep and live in your house, don't do anything. It's best just to leave it in your living trust and get the and guarantee that you get the new cost
The
basis.
kids are going to sell the house, don't do anything. But Leah's not.
Well, she said
Yeah, if they're going to sell the house, don't do anything. All right, next question.
Or not going to live in it.
Yeah.
Well, they're not going to live in these houses, these properties.
Okay, oh, so this has been recorded. We're going to post this on YouTube and on my website, hopefully in the next couple days. It has to be edited, you know, in case of foul language or anything inappropriate. So it'll be up there really soon, joelharrislaw.com or YouTube. Also, I'm a frequent guest on a national podcast called Tricks of the Rich, and they just had me in the studio last week to do this presentation, and you can get it right on your iPhone and the Apple App Store and all that for free. So look for the latest episode of Tricks of the Rich, where I talk about all this in a little more detail with some realtors asking me lots of questions. The disadvantage of rental properties individually being placed into an
I don't
LLC,
think any more than any other attorney.
there really isn't one. The advantage to putting them in separate ones, Michael just talked about, and that advantage is that the liability is contained within that one LLC for if there's any problem with the property.
Joel, can I have a quick follow-up to that?
Yeah,
Yeah, so for Michael, this is actually for Michael, but so I just want to kind of understand what are some of the major drawbacks to putting all 4 rental properties under one LLC? I mean, what are some things, common things that he's seen that could arise perhaps in one rental property where it starts to affect the other 3 rental properties?
Right. So, say if it's a commercial property, you have 4 commercial properties in one LLC.
It would be
So you
all
have
residential. Yep.
all residential. Okay, same thing. So you rent them out, right, as tenants?
Right, correct.
Yeah. Okay. So say if one tenant has a guest, they trip and fall. You know, that's probably the easiest example. Or somebody gets injured at one of the rental properties, and all the rental properties are in one LLC. You know, above and beyond insurance and what the lease says, all 4 properties could be susceptible to the same lawsuit. If you separate them, then you wouldn't have that issue, generally speaking. That's probably the easiest example.
Okay, great, thank you.
Michael, there's a
Moreover, if
question.
a tenant sues you for any reason, you know, and the LLC is named as the plaintiff, the defendant, then you could potentially be susceptible for all the properties in that one LLC. If you separate them, then you wouldn't have that issue, Darren.
Michael, there's a question for you here. Can you do an LLC or a business entity for property out of state?
He has. a-
Possibly.
Yeah, well, the state that's in.
The
I'm
right
pretty
answer
sure
is that
your
the
firm can-
safest answer is to say that it depends on which state, because we have different offices in different states, so it really depends on the state. I mean,
How about Arizona?
Arizona's a great state, but I don't do them there myself.
But about your firm, because you're with Roper's Majeski, you've got offices all over the place.
Right, we don't have one in Arizona though.
All right,
But
sorry.
if you need a
folks.
referral, I can get you a referral in Arizona.
Yeah, Michael's brother is a very successful realtor in Arizona.
Right. He has many suggestions.
Yes, I'm sure he does.
Can,
All right.
can I ask a question?
Joel?
Yeah.
Joel? Hello?
Yeah, I can hear you.
Joel, so as I understand you, you said that the protection of the reassessment in value is not protected under rental property to the heirs, but you may be protected in the reassessment if you transfer the property into a business entity, and you're not restricted to the February date in terms of the transfer into the to the business entity by that date?
Correct. So for the business entity strategy, we don't have a deadline. So what we have to concentrate on right now is if anybody wants to do something with their primary residence. That's the only deadline we're worried about for February 15th. And I'm going to wait until January probably 4th to do anything with anyone's primary residence for a couple of reasons. One reason is that, you know, perhaps Prop 19 will be challenged. The other reason is the city and county and state have all told me I have to close, so I'm just going to work at home until the 4th of January. So I'm going to discuss this with people, and then we'll act after the 4th if it looks like we're going to be stuck with this.
Thank you.
So
I'm
I
going
have
to go
a,
ahead and hold on a sec, folks. I'm going to mute everybody again because I've had a few comments, and I agree that sometimes it's getting a bit loud. So if possible, could you put the questions back in the chat room? Or if you tell me I can unmute an individual person, just kind of like flail around and then your picture will come up on the screen. So if you raise your hand, there's also a button on the bottom where you can, I think you can raise your hand. Otherwise, we're gonna wrap this up at 1 o'clock, and you're welcome to email me if you have any additional questions. If a few people emailed me last week with dozens of questions, and in that case, we'll just set up a consultation in the next week or two, and I can answer all of your questions. I'm going to give you all my personal secret private email address because my business email address hasn't always been behaving. And that's joelharris@aol.com. Please don't give that out without at least getting some cash reimbursement from somebody. Here's a question. If people do not have an umbrella policy, oh, that's a great question. Just for general liability issues, this is for your rental commercial properties and also for your house. I always recommend to my clients that you have an umbrella liability policy. So most of you probably have one. This is a policy that for a small amount of money every year gives you an extra million or millions of dollars in backup liability on your home, your cars, and your rental properties. Sometimes that's just as valuable as multiple business entities. So I would tell most clients maybe just do one LLC, save a lot of money, and then make sure you've got good insurance inside and outside of your LLC. So thank you, Mike Stoiber, retired State Farm agent extraordinaire, for bringing that one up. How can you determine if the proper transfer forms are filed on a property? I'm happy to look at them for you if you scan and send them to me. Otherwise, you would call the county assessor's office and ask them if the reassessment exclusion form has been filed. I just got a notice that my internet is now unstable. At least it didn't say I'm unstable. So if I disappear on everyone, Michael Schachter will take over the program. Next question. For permanently disabled, you're not going to get any additional benefits other than if you are the disabled person. If you're under 55, you can still move 3 times and keep your property tax basis. And you still, get the $1 million exemption on the house, but you're still going to be reassessed on everything else. Good question. Sorry for the bad answer. For anyone who wants to see the slides again or has questions about them, just email me, and you can either see the show again online, or I'm happy to email you all the slides and you can look through them and ask me any specific questions. All right, I've caught up with the questions again. So last chance, everybody. Now you can also reach Michael. Michael, what's your email address?
Michael.Schachter@ropers, ROPERS.com.
Can you type that into the chat for us, Michael?
Sure thing.
So last week, I think I had more people asking for Michael than for me after the program, because a lot of folks did not have a single business entity for their rentals. And that's usually that was a good idea before Prop 19. to protect you from liability and to give all kinds of other planning opportunities. Again, for the folks who send me 20 or 30 questions by email, you're going to get a phone consultation instead. It keeps me out of trouble while I'm stuck at home. And you're welcome, Mike. And sorry you have to leave us, but I have to leave us soon too. I've got appointments all afternoon starting at 1 o'clock. I don't see any other questions. So thank you very much, everybody, for joining us. If you know anyone who would like this information, please have them email me and I'll send them the link to the video and to the podcast. Everybody have a great day. Thanks for signing in. We had more participants this time than last time. We had about 160 participants in the 2 webinars. So that's great. Thanks, everybody.
Thank you, Joe and
Let me know if
Michael.
I can help.
Thanks.
Thank
You're
you.
welcome. Thanks. I'll turn it. Everyone's unmuted. If you know any good lawyer jokes here, I'd like to have them. I'm also, so a big bank has picked this up too. So I get to do this program for all their wealthiest clients. So that'll be fun. Well, let me remind you that this is all in addition to your estate plan and living trust, not instead of. I had someone last week who had a lot of rental properties and so forth and hadn't even done a will or a trust yet. So that's definitely baby step number 1. I'm still meeting with people, don't tell anyone, but I am doing meetings for signings. So if you need something notarized, there's no other way to do it than an old-fashioned meeting. My office isn't pretty much shut down, but I'm allowed to sneak into Antioch, and I've rented a place in Walnut Creek that I can sneak into to notarize for people. And my clients continue to get free notary services. And then hopefully we'll be back in action in January. But my staff likes it. They don't have to see me more than a couple hours a week right now.
I'm curious to know, what do you charge? I have a lot of family members that I keep telling me need to get a trust. What do you charge for, what would be a standard trust?
So for so when I do a trust, Isabel, I do the works. So trust, will, powers of attorney, healthcare directives, property transfer. I have a price range. It starts at about $2,200 for a single person package, around $2,650 for a married couple. If you have handicapped kids or a lot of real estate, that will change. So we always start with a free consultation. So I send out a little worksheet, 4-page worksheet. You email it back to me. We have a chat on Zoom or on the phone. Then I will type up an email, a recommendation with 5 parts: what you should do, the benefits of doing it, other, like most people don't have enough insurance, or long-term care insurance, or umbrella policy. So I'll recommend those. There'll be a list of documents I need, like house deed, and then the fixed fee of what it'll be. And if you're in San Francisco or on the peninsula, you're thinking, holy God, how can this guy be so inexpensive? I'm like a quarter of the price of San Francisco attorneys because I'm in a low rent district. And I love working with people in Hillsborough because they can't believe how reasonable I am. And I'm a certified specialist for decades. So there you go.
You're the best.
That was a
Thank
good question. You're welcome. My pleasure. I got to do something at home. I have clients all over the state now that I email the docs to. You can get them signed on your own. You don't have to come see me, but if you see me, it's free. So I'll sit down and make sure everything is signed right and notarized for free. But if you're anywhere in the state, I can send you the documents for you to take and get notarized. But I can't help you if you're out there. I rely on Michael Schachter's firm. They even help my client in Mexico. They have an office in Mexico City.
It's 1 o'clock.
So, it's 1 o'clock. I'm going to get on to my my next call too. Thank you, everybody. If I can help anyone, shoot me an email. Take care. Have a great day.
Bye-bye. You too. Bye.
Bye, everybody.
Thank you.